Hello everyone, we have to start with case number 29, that is Govinda Pillai, Gopala Pillai versus Aiyyappan Krishnan. Now, if you can see the citation of this case, it is AIR 1957 KER 10. Now, KER is Kerala, so that means we are going to discuss the Kerala High Court judgment today. Govinda Pillai is the appellant in our case and Aiyyappan Krishnan is the respondent in our case. Now, as far as this case is concerned, no new concept we are going to discuss today. Why? Because in my previous videos I have already discussed the basis, or you can say the rationale behind the doctrine of the lis pendens or section 52. And if you can recall, the rationale or the basis behind the doctrine of the lis pendens is necessity rather than the actual or the constructive notice. So as far as this case is concerned, you can use the paragraphs from this particular case in the introduction while writing the answer. So let's start with the case. It says, in execution of the decree, mind you, decree is already passed, so it is at the execution stage that the issue has arisen. So it says, in execution of the decree in the suit, the appellant applied for the delivery of 1 acre of the property in survey plot number this of this place together with the building thereon. So if you can recall, 52 is based when the subject matter, it means 652 will only be applicable when the subject matter is immovable property. So here also it says 1 acre of the property. So it says the contentions of the respondent, that is 102 defendant, 102nd defendant, as summarized by the court below are. Let's see the contentions of the respondent. Now respondent, so that means this person, respondent, is the judgment debtor. Yes, he is the judgment debtor in our case, and appellant is the decree holder in the present case. So it says that the 35th defendant, so let's see the contentions. It says that the 35th defendant, his father, had no rights over the property even on the date of the suit, that the 35th defendant has gifted this property under Exhibit 1 to himself and his mother on 3rd June 1095, underline when this particular gift deed was executed, long before the suit, keep on underlining, long before the suit, that the mother in turn gifted her rights over the property to him under Exhibit 2 in 1101, that if ever since that date, keep on underlining that ever since that date, he is in the possession of the property in his own independent title, that neither he nor his mother was a party to this decree, that the decree is not binding on him and his property, and that therefore the plaintiff is not entitled to get the possession of the property. So he's trying to say here that as far as the suit is concerned, because the rule says that during the pendency of the litigation, no new right should be created. So he's trying to say here that as far as this property is concerned, on the basis of which the plaintiff is claiming the delivery of the property, this respective gift deed was executed much prior to the filing of the suit. Then please mark paragraph number 2. This is the issue of your case. It says the only question, as can be seen from the summary of the contentions extracted above, that arises for the consideration is whether the gift deed dated 3rd June 1095 is affected by the rule of the lis pendens. Because if it is affected by the rule of the lis pendens, then this gift deed is void. And if it is not affected by, then obviously the court will once again restore the judgment of the lower court. Now, third paragraph says, the underline, the plaint, however, was returned for the want of pecuniary jurisdiction. I have already discussed under the explanation that as far as the jurisdiction is concerned, it is divided on the basis of the pecuniary and the territorial jurisdiction. So here they are trying to say that when the plaintiff has filed the plaint, that was returned for the want of the pecuniary jurisdiction, and he has once again filed in the proper court on 29th November 1095. So it is mentioned here, underline under paragraph number 3 itself, that if 29th November 1095 is the material date presentation of the plaint, try to recall, if 29th November 1095 is the material date then it is equally clear that Exhibit 1 is not affected by the rule and that the conclusion of the lower court to that effect has to be sustained. Let me just discuss this paragraph number 3. It says was returned for the want of pecuniary jurisdiction. Now, first he has filed the plaint, but it got returned because of the want of the pecuniary jurisdiction. If the plaintiff himself is taking time, for example, if he has taken 2 months or 3 months, and during that interval, if he has executed any deed in which he has transferred the property, thereby creating new rights, then doctrine of lis pendens will not at all be applicable. So here it says that if 29th November 1095 is the material date, then it is equally clear that Exhibit 1 is not affected by the rule and that the conclusion of the lower court to that effect has to be sustained. Now, paragraph number 4 is telling you about section 52. This we have already discussed. Now, if you can see the citation once again, citation says 1957. The amendment under this particular section came in 1929. So, the extract which is mentioned under paragraph number 4, there are 2 paragraphs. So, first paragraph is talking about this stage before the amendment of the 1929. So, I am not going to read it. Please mark the second paragraph here. It says a second paragraph. The section was amended by the Act 20 of 1929 by substituting the word pendency for the words active prosecution and the words any suit or proceeding which is not collusive for the words a contentious suit or proceeding, and by the addition of an explanation which fixes the time during which a suit is deemed to be pending for the purposes of the section. Now, nothing new we are discussing. This I have already discussed in my previous videos. The section as amended read as follows. So, I am not reading. This is the entire section which is reproduced here. Please mark paragraph number 5. Here it says that there was no transfer of the Property Act. This is important for the exam. It says there was no transfer of the Property Act in force in the Travancore state at the relevant time, and so what we are concerned with in this case is not so much the application of a specific statutory provision as of the general principle governing such matters. So they are trying to say that in the state of the Travancore at that time, TPA was not applicable. So this entire concept is of no help. Please underline this, you have to write in your exam. Lis means an action or a suit. Pendens is the present participle of pendo, meaning continuing or pending, and the doctrine of lis pendens may be defined as the jurisdiction, power or control that courts have during the pendency of an action over the property involved therein. So this we have already discussed. Now please mark paragraph number 6 again. It is important. So they are telling you that as far as the basis of the doctrine in given as follows in the said volume, it says the American jurisprudence they are talking about. It says 2 different theories have been advanced as the basis of the doctrine of lis pendens. According to some authorities, a pending suit must be regarded as notice to all the world, and pursuant to this view, it is argued, read very carefully, it is argued that any person who deals with the property involved therein, the transferor and the transferee parties they are talking about, having presumably known what he was doing, so it will be presumed that he is aware of it, must have acted in bad faith, underline bad faith, not in good faith. Even if it is in good faith, still doctrine of lis pendens will be applicable and is therefore properly bound by the judgment rendered. Other authorities, however, take the position that the doctrine is not founded on the theory of notice at all, but keep on underlining, but is based upon the necessity as a matter of public policy of preventing the litigants from disposing of the property in controversy. That means because of which the dispute has taken place between the parties, the plaintiff and the defendant. So this is the subject matter of the dispute. In controversy in such manner as to interfere with the execution of the court's decree. Without such a principle, it has been judicially declared all suits for specific property might be rendered abortive by successive alienations of the property in suit, so that, keep on underlining, so that at the end of the suit another would have to be commenced, and after that another, making it almost impracticable for a man ever to make his rights available by a resort to the courts of the justice. So unless and until the court is not disposing of the matter which is pending, no right is given to either of the parties, the plaintiff or the defendant, that they can further, transfer the property, they can further create a right in favor of some third person. Then it says, and its origin and history clearly say that the doctrine of lis pendens is of ancient lineage. Originating, it is said, in the civil law, it seems to have been operative at an early date as the basis of the common law rule by virtue of which the judgment in a real action was regarded. So you can leave this, directly come to paragraph number 7, because they are actually extracting the history from the American jurisprudence. Please mark paragraph number 7. You can see yourself, Bellamy versus Sabine case is mentioned here. This I have already discussed. So this you have to write in your exam. It says that in Bellamy versus Sabine case, the entire inverted paragraph is important. It is scarcely correct to speak of lis pendens as affecting the purchaser through the doctrine of notice, though undoubtedly the language of the courts often so describes its operation. It affects him not because it amounts to notice, underline. It affects him not because it amounts to notice, but because the law does not allow the litigant parties, both plaintiff and defendant, the litigant parties, to give to others pending the litigation rights to the property in dispute so as to prejudice the opposite party. So where the plaintiff is actually disposing of the property, thereby creating a right in favor of some third person, it somewhere will affect the right of the defendant, or vice versa situation. The necessities of the mankind require that the decision of the court in the suit shall be binding not only on the litigant parties but also on those who derive the title, third person they are saying, derive the title under them by alienation made pending the suit. So if tomorrow, like for example, X and Y, the dispute is between X and Y, subject matter is an immovable property. During the pendency of the litigation, X creates a right in favor of Z person. So they are trying to say it until the time the court is not deciding the matter in favor of either of the parties, and if tomorrow the court has decided the matter in favor of Y rather than X, and X has already disposed of the property to Z, then this judgment will be entirely binding on not only X and Y but also on this Z person. So it says, whether such aliens had or had not notice, actual or constructive, of the pending proceedings. If this were not so, there could be no certainty that the litigation would ever come to an end. So that means again the alienee, the third person, will file the suit. So in order to stop this, the doctrine of lis pendens is about necessity rather than actual or the constructive notice. Then please mark the next paragraph under the same point which we are discussing. It says that the foundation for the doctrine of the lis pendens does not rest upon the notice, actual or constructive. It rests solely upon the necessity that neither party to the litigation should alienate the property, either creating an absolute right or the limited right, the property in dispute, so as to affect his opponent. Then you can see paragraph number 8 is talking about the mullah. It says that in mullah commentary to section 52 of the TPA, it says, if the plaintiff's valuation is disputed and the plaint returned after inquiry for presentation to a court of higher grade, an alienation, keep on underlining, an alienation effected in the interval, that means once it is presented, it got returned, and before it could be presented to a proper court, the party has actually alienated, that means it has created a right in favor of some third person. So it says if the plaintiff's valuation is disputed and the plaint returned after inquiry for the presentation to a court of higher grade. So he is filed in the lower court, but it should be up to of a higher grade. An alienation effected in the interval is affected by the doctrine of lis pendens. So lower and higher they are trying to say here. Then if this proposition embodies the correct principle, then exhibited one underline if this proposition. So they are trying to say that if we go by this particular proposition, if this proposition embodies the correct principle, then exhibited when is affected by the said doctrine and the appeal has to be allowed. So please put an arrow. Exhibited one means the date of the gift deed, that is 3rd June 1095. So they're trying to say here that if we go by this rule which says that once the plaintiff has filed in a court where it is of lower grade and it is returned in order to file it to a higher grade, then during that interval if the plaintiff has alienated the property, then lis pendens doctrine is affected. So obviously here the gift deed was executed on 3rd June 109, then explanation will be applicable. An appeal has to be allowed. So that means they have to reverse the order of the lower court. But this is just a presumption. Let's see what the court decides. Then paragraph number 9 says that the statement is based on, that means this entire rule is based on Mathan versus Mong Bagyan case, which was decided in 1927. So you can see the citation under paragraph number 9. It says AIR 1927 RANG 145. Now RANG is the Rangoon. So at the time of the Privy Council they are trying to say here when before the application of the Government of the India Act of 1935, if you can correlate, right? And this case that we are discussing, it is of 1957. Amendment took place in 1929. This Mathan versus Mong Bagyan case is of 1927. So here it says the statement is based on Mathan versus Mong Bagyan case. Read very carefully. In that case, a suit was instituted in the township court at Gol, which could only deal with suits up to 500 in value. So this was the maximum limit or the valuation of the suit. The defendant filed a written statement in which he pleaded inter alia that on the correction that on a correct valuation, the suit will be found to be beyond the pecuniary jurisdiction of the court. The court framed a preliminary issue. So plaintiff has filed, there's an objection came from the side of the defendant that as far as the valuation of the suit is concerned, the court needs to once again go through it. So court has framed a preliminary issue regarding the proper valuation of the suit, took evidence as to the acreage of the holding and the value per acre, and on 14th of May 1920 recorded a finding that the proper valuation of the suit would be rupees 750, much higher than 500. On the basis of that finding, it directed that the plaint be returned for the presentation to the proper court. The proper court was the subdivisional court at Aiyyappan, and the plaint was presented in that court on 21st May 1920. So proper court presentation, underline 21st May 1920. Now we have to see that what happened. So it says on the 20th May 1920, the defendant, one of the parties, was actually, disturbing the right of the other litigating party. So it says on 20th May 1920, the defendant, that means one day prior, on 20th May, underline on 20th May 1920, the defendant executed a conveyance of the land. So that means he has created a right in favor of some third person, executed a conveyance of the land, and the question before the court was whether the said conveyance was vitiated by the rule of the lis pendens. He stated the question for the decision as follows. Let's see the judgment. It says the question which thus comes before us in this appeal is whether in a case where the subject matter of the suit is land, immovable, and the valuation which the plaintiff puts on the land is disputed, and where the proper valuation is after inquiry found to be beyond the pecuniary limits of the court, because the pecuniary limit of the court was 500, in which the plaint was presented, so that the plaint is returned for the presentation in another court, and where further the plaint is so presented without undue delay, a transfer made, underline, a transfer made in the interval between the return of the plaint and its presentation to the proper court is a transfer which is prohibited by 52 of the TPA. So they are trying to say that on this also the doctrine of lis pendens will be applicable, and answer the question in the affirmative. Now you can see that there are other cases also. Tengore Majari versus Jaladhar case, this you can read yourself. Directly come to paragraph number 12. It says, whatever may be the correctness of the decision on the basis of 52 before the amendment. So the cases which we have discussed, it is before the amendment. So it says, underline, whatever may be the correctness of the decision on the basis of section 52 before the amendments affected by Act 20 of 1921, it cannot be, underlined, it cannot be considered as a correct interpretation of the section as it stands today. In Gauri Dutt versus Shankar, please see the citation AIR 1933 Sindh 117, the court said that the legislature has thought fit to amend the provisions of section 52 TPA by Act of 1929, 2 years after the case in AIR 1927 Rang. Underline AIR 1927 Rang. They're actually talking about Mathan versus Mong Bagyan case, that is mentioned under paragraph number 9. So it says the legislature has thought fit to amend the provisions of 52 Act by the Act 20 of 1929, 2 years after the case in AIR 1927 Rang 145 was decided, to make it abundantly clear that the pendency of the suit or the proceedings for the purpose of the doctrine of lis pendens, underline, shall be deemed to commence from the date of the presentation of the plaint or the institution of the proceedings in the court of the competent jurisdiction. Underline, the Rangoon case is therefore no longer a good law, and added, directly come to the last 4 lines of this paragraph on page number 153. It says, in a number of rulings it has been held that where the suit had been instituted in a wrong court and the plaint has been ordered to be returned, the period of limitation, so they are actually correlating with the section 14 of the Limitation Act. So that means if bona fide you have filed the application in a wrong court and the court has returned the same application or the plaint in order to file it to a proper court, that entire period will not be included. It will be excluded from your period of limitation. So for example, let me just take a hypothetical situation. For example, the limitation period is of 30 days and you've wasted your time bona fide keeping in mind that this is the X is the proper code, whereas it turned out to be a Y code. So if 10 days you have wasted in X code, so that 10 days will be excluded and it will be added into your remaining days. So it says, in a number of rulings it has been held that where the suit has been instituted in a wrong court and the plaint has been ordered to be returned, the period of limitation does not commence, underline, from the date when the plaint was first presented, but from the date when it was subsequently presented in the proper court. So excluded and added. Although it is open to the plaintiff to rely upon the provisions of 14 to claim the exemption for the time during which he was prosecuting with due diligence and in good faith his first suit. Now directly come to paragraph number 13, the second paragraph which is mentioned here. It says, the mortgage was executed after 52 was amended by the TPA. The only order that was made in the proceedings pending at the time when the mortgage was executed was an order that the plaint, read very carefully, that the plaint should be returned for the presentation in a proper court. The suit in which the decree for the partition was passed was not instituted until after the mortgage was executed, and therefore the doctrine of lis pendens cannot apply. Then lastly it says, we take the view that 52 of the TPA as it stands today after the amendment embodies a correct version of the rule of the list pendants, and that it is that rule that should be applied in this case. If the said rule is applied, underline this is the ratio, if the said rule is applied, there can be no doubt that there was no suit pending in a court of a competent jurisdiction prior to 29th November 1095, and that Exhibit 1 dated 3rd June 1095 should hence be held as not vitiated by the rule of the lis pendens. Lastly, it says, it follows that the lower court's decision is correct and has to be affirmed. The appeal falls and is hereby dismissed with cost. So this is about the doctrine of the lis pendens, the rationale behind the doctrine of the necessity, not based on the actual or the constructive notice. So in the next video, I'll start with the next case, which is the last case for this particular unit, and the remaining essential ingredients. Thank you.